Number 11 is actually about the access to justice, so I'm going to talk about that. And I am the critic for democratic reform, so I am taking this issue from the democratic rights perspective. There have been, by this government, a number of attacks on our democratic rights in this province. Because of those attacks, including the changing of the rules of the Toronto's municipal election, when that came back in 2018, they changed the rules midway through the campaign. When that came back from the Supreme Court ruled in a 5-4 decision that Canadians do not have the right to democratic municipal elections. And most people don't know that, and that's why I keep repeating it in this legislature, because people need to be aware that we do not have the right to democratic municipal elections, and this is something that we need to get restored, because I think for the last 160 years that we've been a country, when people go to the polls in a municipal election, they're assuming that the X that they mark on the ballot is the highest law in the land, and that it cannot be overruled. But that's not the case. That's not the case in Canada. It's not the case in Ontario. And so that's something that we need to restore. The other action from this government is that once they got that was in 2021, that the Supreme Court decision came back. Once they got that decision, then they passed what were called strong mayor's bills. And those strong mayor's bills stripped the majority of municipalities of the right to majority vote democracy. So in the majority of municipalities and the majority of Ontarians do not have the right to majority vote democracy anymore. And the other thing that this government's done that's an attack on our democratic rights is they've passed 3 bills, or they've introduced 3 bills in this legislature that utilize the notwithstanding clause. And most people don't know, it's a bit of a euphemism, the notwithstanding clause, but it strips the notwithstanding clause, and it's from section 33 of the Charter of Rights and Freedoms. And I realized, I was talking to my colleague from Humber River Black Creek, and he said that, you know, when you speak, that I often sound like a friendly professor. And that's the attitude that I'm trying to approach, to have today, the friendly professor, because I really want people. The member for Niagara Falls says I actually look like the friendly professor, and I was the friendly professor before I got here. I was teaching at York University. So let's see. So I just want people to be aware of how important our democratic rights are and how they're being attacked and being taken away under this government, including our right to the access to justice. So section 33, this notwithstanding clause, it actually reads, let's see, that a legislature, a provincial legislature or the federal government can pass a piece of legislation that shall operate notwithstanding a provision included in sections 2 or sections 7 through 15 of the Charter. And section 2 of the Charter of Rights. So what they're doing is they're saying a provincial legislature can pass a piece of legislation that overrides section 2, which is our legal rights, or sorry, our fundamental freedoms, our freedom of speech, our freedom of religion, our freedom of conscience, our freedom of association. All those fundamental freedoms have been overridden by this government 3 times with 3 separate pieces of legislation. Sections 7 through 15 of the Charter include our equality rights, and section 11 is our rights in legal proceedings, and specifically in section 11 it says the right to an independent and impartial judge. So we have a charter right to an independent and impartial judge if we have to go before a court. And this government's passed 3 pieces of legislation that strip Ontarians of that right. And now, what's most concerning, over the last couple of years, the Attorney General and the Premier, the Conservative Attorney General and the Conservative Premier, have taken steps to strip us of that right to an impartial and independent judge. And it started in 2019 when the Attorney General said that he wanted to appoint like-minded judges. He wanted to have judges who had similar values to his own. And then in 2020, we found out through the media that the Attorney General was actually interviewing Chief Justice candidates. So these people were applying to be the Chief Justice of the Ontario Court of Justice, and the Attorney General was personally interviewing them. And then in 2022, the government passed Bill 245, which stripped the Judicial Appointments Advisory Committee of their power. And this Judicial Advisory Appointments Committee They are the ones that make recommendations. So they're the ones who are supposed to interview judicial candidates, and they're supposed to make recommendations to the Attorney General, and the Attorney General is supposed to choose one or however many they need from that list. But instead, the government passed a piece of legislation that stripped that independent committee of most of their powers. And so this government is now appointing the judges directly.